Illinois has a complex late fee framework where state law provides a foundation, but Chicago and Cook County add significant local requirements that create a multi-layered compliance challenge. The governing law includes the Illinois Landlord and Tenant Act, found in 765 ILCS 705 and 765 ILCS 710, along with the Chicago Residential Landlord and Tenant Ordinance, the Cook County Residential Tenant and Landlord Ordinance, and general contract principles. If you're a landlord or tenant in Illinois, what rules apply depends heavily on where your property is located. Let's start with the state-level framework. Illinois does not impose a specific statewide statutory dollar cap or percentage cap on late fees. At the state level, the fee is governed by the lease terms and general contract principles, specifically the requirement that the fee be reasonable and not function as an unenforceable penalty. Illinois does not mandate a statewide grace period. At the state level, there is no law requiring a specific number of days before a late fee can be charged. If your property is outside Chicago and Cook County, the grace period is governed by the lease. The reasonableness standard under Illinois contract law is the primary state-level limitation. A late fee is a liquidated damages provision, and Illinois courts apply the standard analysis. The damages must be difficult to calculate at the time of contracting, and the fee must be a reasonable estimate of anticipated damages. Illinois courts have struck down late fees that are grossly disproportionate to the landlord's actual costs. Now here's where it gets complicated. Chicago. The Chicago Residential Landlord and Tenant Ordinance, known as the RLTO, imposes specific requirements that significantly affect late fee enforcement within the city. Under the RLTO, landlords in Chicago must provide a 5-day grace period before charging a late fee. If rent is due on the 1st, the late fee cannot be imposed until the 7th. The 5-day grace period is mandatory within Chicago. The RLTO also requires that the late fee be specified in the written lease. A fee that isn't documented in the rental agreement is not enforceable. The lease must clearly state the fee amount, the grace period, and when the fee applies. Chicago's RLTO requires that the late fee be reasonable, and Chicago courts have been relatively strict in evaluating reasonableness. Fees in the range of 5 to 8% of the monthly rent are generally considered defensible. Fees significantly above that range face challenge. The consequences of violating the RLTO are severe. The RLTO provides tenants with the right to recover damages for violations, and Chicago courts have awarded significant damages to tenants whose landlords violated the ordinance. The RLTO also allows the tenant to terminate the lease in response to certain violations. A late fee provision that violates the RLTO creates liability that far exceeds the fee itself. Cook County, outside Chicago, has its own residential tenant and landlord ordinance that adds additional requirements. The Cook County Ordinance applies to unincorporated Cook County and to municipalities within Cook County that have adopted it. Landlords in suburban Cook County must verify whether the Cook County Ordinance applies to their specific property location. The Cook County Ordinance includes tenant protections similar to Chicago's, including requirements for written lease provisions and restrictions on excessive charges. Landlords operating in Cook County should verify current requirements and ensure compliance. Municipalities outside Cook County generally operate under state law without local overlay, giving landlords more flexibility. Landlords in DuPage, Lake, Will, Kane, and other Collier counties follow the state framework, where the reasonableness standard is the primary limitation. This creates a 3-tier system. Chicago properties must comply with the RLTO plus state law. Cook County properties may need to comply with the Cook County Ordinance plus state law. Properties outside Cook County follow state law only. A landlord who owns properties across these jurisdictions may need different late fee provisions for each tier. The lease must clearly state the late fee terms, regardless of jurisdiction. The lease should specify the rent due date, any grace period, mandatory in Chicago, the exact fee amount or formula, when the fee triggers, whether additional charges apply for continued non-payment, and whether the fee is defined as additional rent. Compounding late fees in Illinois must satisfy the applicable reasonableness standard, which is stricter in Chicago than in downstate communities. A single one-time fee is the safest approach across all Illinois jurisdictions. Daily or weekly compounding is risky in Chicago, where the RLTO's tenant protections create heightened scrutiny. Outside Chicago, compounding must still satisfy the state-level reasonableness standard. The interaction between late fees and the eviction process in Illinois is governed by the Illinois Forcible Entry and Detainer Act, 735 ILCS 59-101 and following. Illinois requires the landlord to provide a 5-day notice for non-payment of rent. The notice must demand the specific amount owed, and that amount must be accurate. Whether late fees can be included in the 5-day notice depends on how the lease defines them. If defined as additional rent, they're includable. If not, the landlord may need to pursue them separately. Best practice: define late fees as additional rent. In Chicago, the eviction process has additional procedural requirements under the RLTO, including specific notice content and timing requirements. A late fee that violates the RLTO can become an issue in Chicago eviction proceedings. The tenant can raise the violation as a defense or counterclaim. Illinois courts in Cook County handle a massive volume of eviction cases. The Daly Center's eviction courtrooms process thousands of cases. Judges and tenant attorneys are experienced with late fee disputes. Non-compliant fees, particularly RLTO violations, are identified and challenged routinely. Illinois does not impose a statewide cap on security deposits. The deposit amount is governed by the lease. However, Chicago's RLTO and the Cook County Ordinance have specific deposit requirements, including interest payments and receipt requirements. The deposit must be returned within the applicable timeline, 30 to 45 days depending on jurisdiction. Unpaid late fees can be deducted if compliant. In Chicago, the RLTO requires the landlord to pay interest on the security deposit and to hold the deposit in a federally insured, interest-bearing account. The landlord must provide a receipt showing the financial institution, the amount, and the account type. Failure to comply with Chicago's deposit requirements can result in the tenant recovering twice the deposit amount plus attorney's fees. These strict deposit rules mean that deducting non-compliant late fees from the deposit in Chicago compounds the violation significantly. For tenants receiving housing choice voucher assistance, common in Chicago and other Illinois cities, landlords should not charge late fees when the housing authority's portion is delayed. Illinois prohibits source of income discrimination under the Illinois Human Rights Act. Landlords cannot discriminate based on the tenant's use of vouchers or other lawful income sources. Penalizing a voucher tenant for the authority's delay creates both a late fee violation and a discrimination claim. Illinois' military population is centered around Scott Air Force Base near Belleville, home to United States Transportation Command and Air Mobility Command. Scott AFB generates significant military and civilian demand in the Metro East region. The Rock Island Arsenal in the Quad Cities generates additional military demand. Great Lakes Naval Station, north of Chicago, is the Navy's primary boot camp. Though trainees don't typically rent off base, the permanent party and instructor cadre do. Military pay is predictable, and most military tenants pay reliably. SCRA protections apply to active duty service members renting anywhere in Illinois. From a practical standpoint, Illinois has one massive metro and several secondary markets, each with different late fee dynamics. Chicago is the state's dominant market, the third largest city in the country with an enormous and diverse rental landscape. Rents vary dramatically, from $3,000 in Gold Coast and Lincoln Park to $800 in South Side and West Side neighborhoods. The RLTO applies uniformly across the city, regardless of neighborhood or rent level. Chicago's massive student population, University of Chicago, Northwestern, DePaul, Loyola, UIC, Columbia College, and many others, creates significant rental demand. Student late payments correlate with financial aid processing. The 5-day grace period covers most delays. Chicago's hospitality and service workforce, hotels, restaurants, tourism, has income that fluctuates with seasonal demand and convention schedules. Late payment patterns may correlate with slow periods. The Chicago suburbs in DuPage, Lake, Will, and Kane counties have strong markets with professional tenant bases. These suburbs operate under state law, not the RLTO, giving landlords more flexibility. Late fee enforcement is standard with typical flat fees and 5-day grace periods. Suburban Cook County is the tricky middle ground. The Cook County ordinance may apply, creating RLTO-like requirements outside Chicago. Landlords in suburban Cook County must verify their specific compliance obligations. Springfield, the state capital, has a moderate market driven by state government. Government employees pay reliably. Peoria, Rockford, and Champaign-Urbana have moderate markets. Champaign-Urbana, home to the University of Illinois, has student-driven demand. The Metro East, Belleville, O'Fallon, Edwardsville, has a moderate market influenced by Scott AFB and proximity to St. Louis. Military tenants provide reliable demand. Bloomington-Normal, home to Illinois State University and State Farm Insurance, has a unique combination of student and corporate demand. Decatur, Quincy, Carbondale, and smaller Illinois communities have affordable markets. One best practice for Illinois landlords: determine your compliance tier before drafting your late fee provision. Chicago properties must comply with the RLTO. Cook County properties may need to comply with the county ordinance. Everything else follows state law. If you own properties in multiple tiers, maintain separate provisions for each. A provision that works in Naperville may violate the RLTO in Chicago. Another best practice: in Chicago, comply with the RLTO meticulously. The 5-day grace period is mandatory. The fee must be in writing. The fee must be reasonable. Chicago's tenant advocacy organizations, including the Metropolitan Tenants Organization, Lawyers Committee for Better Housing, and Legal Aid Chicago, actively educate tenants about RLTO protections and assist with challenges. Assume your fee provision will be scrutinized. A third best practice: keep detailed records of every late fee charged across all jurisdictions. Whether you're in Chicago's heavily regulated environment or a downstate community with minimal regulation, consistent documentation protects you. Record the due date, date received, grace period calculation, fee amount, and the fee's basis in the lease. These records are essential for clean eviction proceedings, particularly in Cook County's high-volume eviction courts. For the complete guide to Illinois late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.